course, you got the motion I just drafted for conditional default. I also attached a 3-page little synopsis in the interrogatory, plus the meeting minutes, and we got all that.
I'll review. And look, if they're responsible, I mean, you're entitled to strike the conditional default.
And you got the 300-page appendix that went with this case.
Yeah. I mean, I'm curious, were you on the civil cases this morning? Were they condominium association cases? They look like it from the...
The first one was, but...
I'm just curious to see what
the second one I'm not so sure. It's a development, I think.
Curious to see what... Whether it's under lien cases.
Yeah. Well, they received judgment of some sort.
I also have a memorandum that's going to come with this right here, a memorandum of law. Should get it tomorrow morning.
You're going to mail it to me? Yeah.
No, I'm just going to hand it to you.
Oh, that's right. We got to hear it tomorrow. Yeah.
So, what are you trying to get out of this attachment thing? What's that?
Town has a final judgment. So, you know, we have an attachment on those settlement proceeds. Those are payable over to the town. So, you know, I'm looking to have the judge order that Hawkins or the insurance company pay those funds directly to the town of Bartlett. Not to me, but to the town.
Right. What about you got attachments on my real estate and stuff? So what do you intend to do with that?
I'm not going to reveal what I'm going to do. I mean, I'm going to consult with the town and whatever they feel is appropriate to enforce, you know, their judgment. If we figure this is appropriate, we'll do. I think you should get counsel. I mean, you really should, because I think you got a problem with your mortgages.
Mortgages? What do you mean?
Your problem go beyond me. The town of Bartlett's not your biggest problem.
Can you explain?
You got a mortgage after the town asked to attach your property. And if you didn't disclose that attachment procedure, the bank, they're not going to call
I got a mortgage after the attachment? A refinance?
I don't know, but it looks like they distributed $200,000 to you after the attachment went on. And if you didn't disclose that attachment, I'm not your biggest problem.
Yeah.
You got a bigger problem with the bank. They're not going to call James Chandler. They're going to call the USA. So you should get counsel. I can't advise you. You got a much bigger problem than me. And, you know, Gene not showing up here for a hearing. You got a big problem with the bank. That's what you're doing.
The bank? The bank? Which bank?
The bank figures out what happened. They're going to be looking at you. They're going to be looking at you.
What are you talking about?
Look at the registry of deeds.
What property?
All right.
You gotta let me know you're going to get it. I'm not on the record yet.
Good afternoon, you may be seated.
Thank you, Your Honor.
This is document number 212, 2015, CB32, Starbright Leasing Inc. and Edward C. III versus Gene Chandler. This afternoon we have court index number 20.
ordered Mr. Furlong's arrest. That's my best understanding of what remains in the case. And so my position is, given that narrow factual circumstance which remains, we should file, or the plaintiff should file a narrow, more particular statement alleging facts which arise out of that transaction or occurrence such that I can answer it in a straightforward manner. That's going to inform what discovery we should have. It's going to inform what the actual factual disputes are here in this case. And it's going to streamline the case significantly. So, I mean, that goes into the motion for a structuring order. What I told Mr. Furlong is I have some concerns entering a structuring order now before we can even answer. I mean, it very well could be, depending on what the more particular statement says. I mean, there could be 1 or 2 paragraphs where we have the factual dispute. And if that's the case, discovery can be much more narrowly tailored to those disputes. So what I'm asking the court to do is simply to ask Mr. Furlong to file a more particular statement that focuses on the only sole remaining issue in this case, which I understand to be the allegation that Mr. Chandler ordered Mr. Furlong's arrest. That's going to make this case much more simple. I think it's going to be much more amenable to dispositive motions either way. And I think it'll be much more effective to administer justice. So I'm happy to answer any questions that you have.
Very good. Thank you. Mr. Furlong, your response.
Good afternoon, sir. How are you today?
I'm well. Good afternoon to you.
Thank you. Mr. Hilson wants me to amend the complaint to specify more specific to the one allegation or the one count that Gene Chandler had me falsely arrested. I mean, I'm not making no excuses about not having a law degree, but the complaint clearly is a little verbose in its center and its meat and potatoes. But in the front part of the complaint, the title, the parties, jurisdiction is all correct. And then I get a little verbose, and I get verbose because, quite frankly, I feel that pro se litigants sometimes need to be a little verbose. I don't know why that is. I just have that feeling that it just needs to be, because if not, then if it comes up short, and then there's going to be somebody crying about it's too short. So, and then on the end side of it, where the counts were, this was a case in equity. I'm not asking for any money. I'm asking to have Gene Chandler removed. And then on the back side of it, my prayers were the count is that he had me falsely arrested. And my prayers request that he is to be removed from office or disqualified. Mr. Hilson has a habit of making me work for his to prosecute his client. For example, I just received like 4 motions from him, and I want to apologize to the court right now because he filed a motion for a conditional default. And I had 10 days to answer it, but I wanted to get it into court today because I know you're leaving Friday. Tomorrow will be your last day here. So I was trying to draft a more important document, a document to vacate this fraudulent attachment. And while I was doing that, I received all these other flurry of motions from Mr. Hilson, which I think, they're without merit, and they clog up my calendar. Yes, ma'am. They clog up my calendar, for things that I need to do that are pertinent to these cases. For me to draft another complaint, be more specific, is just another way of him making me work harder at prosecuting Gene Chandler. And I just don't feel it's necessary at this point. I think the evidence is conclusive to what I have against Gene Chandler. And so it's totally up to the court, Your Honor, to order what you got to order. I mean, so.
My view of it is, I think I was pretty specific in my order in terms of that I could not find that the allegation that Chandler used his authority to falsely arrest failed to state the claim that he breached his oath of office as a selectman, and that's stating the claim under RSA 42.1. Then I went on to say there's two very strict limitations here. First of all, this is equitable. It's not a claim for damages. It can't be the way RSA 42.1 and 42.1a reads. So I made that very clear and cited to the appropriate cases, especially the federal district court case. And then held that you can't retroactively invalidate any action taken by Chandler because RSA 42.1 and 42.1a did not allow you to do that. So the claim survives, but only insofar as it relates to a claim for dismissal of Mr. Chandler, which is based solely on the alleged false arrest. All the other claims and counts have been dismissed. My view of it is, without giving you a whole lot of extra work to do, is for you to just file an amended complaint. I can give you 30 days to do that, so you have time to do that. That very, very specifically sets forth your claims under RSA 42.1 for dismissal based on your March 2015 arrest and nothing else, because that's what has survived the dismissal. And I think that the decision is very clear on page 11 into page 12 as to what has survived. And it's that very narrow claim that you made, Mr. Furlong, that Chandler directed the Bartlett police to falsely arrest you in March of 2015. And based on his conduct as it relates to that March 2015 arrest, he is subject to dismissal for violation of his oath of office under RSA 42.1. In my view, if you do an amended complaint that is specific, direct, and alleges those grounds for dismissal, then Attorney Hilson will have a very easy time admitting and denying whatever facts you have in there. I went over the complaint again today because I thought, well, maybe I can go through here and say, okay, Attorney Hilson, you have to answer these three, and I couldn't do it. I tried to make it easier so you wouldn't have to amend it, but I can't. I really stress to you, though, that I think you and I have a fundamental disagreement as it relates to self-represented litigants. I think the more specific, focused, and succinct you are, the better off you are. Verbosity, in my view, could probably state that in a very brief amended complaint. You can then answer it, Attorney Gilson, and we can structure it up, because I would guess that my structuring order on this type of claim is going to be for a much shorter duration than it would have been on all of the claims in this case, especially in light of the fact that it's in equitable proceeding. We're not going to have a jury trial. I would think that we could structure this out over a period of 6 months from beginning to end, as opposed to the normal 12 months plus on a jury trial type of claim.
Can I be so presumptuous to possibly request a couple conditions with my amended complaint?
Go right ahead.
One condition would be that I could enter in a perjury count, that I feel that I can have enough corroborating evidence of material fact to sustain a perjury count. And the other request or condition, of course, would be that you grant the motion for special assignment, because I believe Judge Ignatius is going to have her work cut out for her on other cases, and you are privy to this case. You know all the ins and outs. So those are my two requests to this court. But I have no problem amending the complaint. But I feel that there's a perjury count sticking out there that it's within the statute of limitations of 3 years, that I can corroborate through evidence.
Attorney Nielsen, I can't rule on the motion to specially assign the case to me. I'm not permitted to do that. That has to be done by Chief Justice Neto. She controls all the assignments, so I myself can't rule on that. What will happen with that request will go to the Chief Justice, and she'll make a ruling. I don't control the cases that I take from this courthouse down to that. I just can't do that. So that motion will be referred out to her for a ruling in this case and any other cases. It's final on.
Are you allowed to recommend on the special assignments?
I just let her do her job. I don't interfere with it at all at this point. So, Attorney Nielsen.
I guess first, you learned something about me today. I didn't know that. I didn't know. It makes sense that it would go to the Chief Justice. I know I've never dealt with a motion for special assignment before, but going to the first condition, if you will, that he be able to get another bite at the apple to re-articulate, I guess, a cause of action to remove Mr. Chandler on the basis of a perjury, an alleged perjury. He really tried to pitch that in the first complaint. In other words, a lot of what is in the initial complaint is revolving around this allegation that Mr. Chandler somehow perjured himself. It's not true. It's about a comment that was made at a selectmen's meeting. No one's under oath at a selectmen's meeting. I guess what I'm saying is he's had a full and fair opportunity to try to articulate that claim. He failed to do so, and it really lacks any merit anyway. I think what you're doing is you're reopening the door, and we're just going to have to file another motion to dismiss based on the same grounds, and you're creating more work for everybody. You put in a very well-reasoned memo on your motion to dismiss. His opportunity is to take that up to the Supreme Court at this point in time. Thank you, Ron.
You're welcome.
Your Honor, I guess there's some other motions out there regarding discovery. I think they flow naturally from the resolution of the Moore particular statement. In other words, it seems like to me, if you order him to file a more particular statement, great. I'll answer it as the court will provide. We can put together a structuring order based on that answer and process the case from there. And so I don't know, maybe this is more that. So there's some other things here that I think logically fall into place. The only other thing that I would, there's some interrogatories hanging out there right now, which I've asked for a protective order to not have to answer them until we get this. I guess I would ask that you encompass a resolution of that issue in connection with the order here today.
May I speak, Your Honor?
Yeah, let me just write this first, and then I'm going to address everything else, so I'll allow you to speak next.
Thank you.
Just write this out, so I don't...
Appreciate it.
Thank you. All right, I'm going to issue the following order, and then we'll discuss any other motions and any other discovery issues, just so we can address them going forward. The defendant's motion to compel a more particular statement is granted. The plaintiff shall file an amended complaint setting forth the RSA 42-1 claim for dismissal against the defendant for his alleged involvement in the plaintiff Furlong's arrest in March of 2015. This is a limited and narrow claim that the defendant breached his oath of office as a selectman. See RSA 42-1, New Hampshire Constitution, Part 1, Article 84. Also see order on defendant's motion to dismiss at page 11 and 12 or index number 25. I think in pages 11 and 12 I set forth exactly what this narrow claim is. The amended complaint shall be filed on or before April 1, 2016. The defendant's answer shall be filed on or before May 1, 2016. A case structuring order shall be filed by the parties on or before May 20, 2016. So I think at this point, from my view from the bench, is that we've got to get the amended complaint in, we've got to get the answer in, you've got to structure the case out in terms of your interrogatory deadlines, your expert deadlines, if any, your deposition deadlines, dispositive motion deadlines, your ADR mediation, all of that's got to be structured out. And then you can move forward with your discovery. I think at this point, in terms of whether it be discovery by interrogatories or depositions, it's a bit premature until you get through the pleading stage of getting the amended complaint in and get the answer in, so that as you proceed with interrogatories and discovery, you're aware of what you can discover. And the discovery is going to have to be related to this narrow claim that he breached his oath of office as it relates to your alleged false arrest in March of 2015. You cannot go into discovery that relates to all the claims that have been dismissed. In terms of the perjury claim that was made in your initial complaint, that was dismissed under my order. It was dismissed without any holding for you to come in and amend it, because as pled, a civil complaint seeking damages for what amounts to be criminal perjury is not alleged to have any recovery under New Hampshire law. It's just not a claim for relief. There's no way to amend that to state a cause of action in my view. I don't want to repeat my decision on that, but I think if you take a look at the order on counts 1 through 6, my ruling on all of those counts were supporting independent claims that were really based on violations of various criminal statutes and did not state a civil claim for relief. And there is no way to do that under the cited 2 statute, because they're criminal claims. There's no way to amend those. So
motion to strike the conditional default is granted, or
Let me take a look at that.
assuming?
Put them in the file.
Just to let you know, he did get the answer to the interrogatory. I gave it to him, 3-page answer, plus some attachments to it as well. You have a copy of it, sir, with the affidavit that I submitted. Motion for protective order as well. It's in that, in my prayers. I would like to just ask this court a few more questions before we close this.
Let me just take a look at some of the, I'm going to allow you, and I know that Attorney Hilson may have other things to say about it. In terms of the motion for a special assignment, Judge Temple, what I will say, because I've read that, what I will say is, as I said at the last hearing, Judge Barber can have nothing to do with these cases. He is walled off from these cases. If I am not assigned to these cases and Judge Ignatius takes them over, she will not be talking with Judge Barber at all. She can't, under the canons of judicial ethics. She will have to make those decisions on her own. For instance, in all the time that I've been up here for over a year, I have never discussed your cases with Judge Barber at all. I cannot, based on the conflict that he has. So that just cannot happen at all. So she won't be doing that. What I'm going to do on that, though, is just refer it to the Chief Justice for a ruling.
For your own knowledge, sir, I know Judge Barber personally, and I've seen him in the grocery store many times and said hello to him. However, his wife does work for Cooper Cargo and Chant. So, thus...
Conflict, that's why...
Right. But as far as Judge Barber, I think he's a good man, a good judge, and him and I go back quite a ways.
I agree with you on that.
Yeah.
He and I go back, way back.
Yeah. Judge Green and Judge Payne and all those wonderful judges. I've lived here in the Valley for 32 years, and they're all good judges, so including Judge Barber. But like I said, I think his wife does work for Cooper Cargo and Chant, and so that kind of precludes Judge Falver hearing anything about the cases.
So, you and I agree. All right, the motion for special assignment. Attorney Hilton with objection. Recording that number 34. My view of those is that at this point, any ruling is probably best kept until everything is done with the amended complaint and the answer. I will say this, though, Mr. Furlong, in terms of your interrogatories, my view is that the interrogatories in this particular case can only be directed at a party. The interrogatories have to be directed to the defendant, Mr. Chin. You can't do interrogatories in this proceeding out to a variety of different people. Now, if there are interrogatories that are related to this claim, in that in order to seek out the answers, Attorney Hilton has to consult with certain non-parties, then he will do that, and that information will be reflected in the answer. But to the extent that interrogatories are going out to a variety of different people who are not parties, I don't think that's an appropriate use of interrogatories. In terms of depositions, again, as long as the depositions are related to this statutory claim of breach of oath of office, you can take depositions, again, in compliance with the structured order that we'll get after we're done with the complaint answer. You can do those as part of the discovery process. Nothing says you have to do your discovery through interrogatories. I found in my practice, quite frankly, that if I used interrogatories, they were for some very foundational information. But where I got my real discovery was in depositions. On the other hand, we can address the need for protective orders if depositions are being requested of people who have no knowledge about this particular claim, and it's just going to be a waste of time for everybody. We're not going to go on a fishing expedition. It's going to have to be interrogatories and depositions that are going to lead to the discovery of relevant evidence related to this particular claim. Do you understand what I'm saying?
Absolutely, sir, absolutely. And the only people that I want to propound interrogatories to are the people that sit in the selectman office next to Chandler when they decide that I should be arrested, which would be Selectman John Hebert and Selectman David Patch and their secretary, who by their own right would maybe be afraid to lie in an interrogatory to cover up their boss, Gene Chandler, and may be more truthful than Gene Chandler. So David Patch, John Hebert, and Brenda Malarios are the only ones that I would wish to propound interrogatories for. But I agree otherwise with you wholeheartedly, because most of the time they're directed with counsel sitting next to them, and you get a lot of boilerplate answers. But I still feel that the interrogatories are very pertinent in regards to John Hebert and David Patch. Not so much maybe the secretary, but those two men, they're a team with Gene Chandler as chair, and I think it's crucial in this case that I propound interrogatories to those other two men. Depositions go without saying. I definitely want to depose them. And as far as the perjury request to you, I should have reworded it that I'm looking to also enable another count of violation of the Part 1, Article 4 of the Constitution, violation of oath of office. I have interrogatories, affidavit from Gene Chandler from 2012 that falls in with 3 years of a statute of limitations, where he is lying in comparison to other members of his office, one being Annette Libby, Doug Garland, that I have depositions from 2012 case, that are totally, someone's lying, okay? And I had that. It's solid, and it falls within and that's a violation of his oath of office, telling untruths. So, I mean, the name perjury, or the count perjury, can be misleading. But and this here would also corroborate the allegations that he had me falsely arrested. So I can go home and do my homework and come up and make sure that I put a different name to it than other than perjury, because it does fall under a criminal statute. But in this case, I certainly can find the right cause of action to include with that he had me falsely arrested. And I just, and I spent a lot of money on those depositions, and I have them, and I have his affidavit, Gene Chandler's affidavit from, I'm not certain of the date, it could be from the late 2011, but his affidavit is immaterial. His interrogatories were propounded in October of 2012, and where the lies come in at. So I may be mistaken about using the term perjury, and I want to, recant that. I mean, but I would like you to consider that I can bolster the primary allegation that he had me falsely arrested.
The only thing I can do today, for what's been filed, is tell you to file an amended complaint if it relates to your RSA 42-1 claim that he was involved in your allegedly unlawful false arrest in March of 2015. That's my order for today. I can't prevent you from filing any motion to amend that you want to file and then ruling on it. But I can't also sit here from the bench and give you advice on what claims you should file and what they should say. I just can't do that.
Yeah, I'm not asking.
Today is, I had a set of claims in front of me. I dismissed all of them except one very narrow claim that we've gone over today, and I'm now requiring you to file an amended complaint on that. In terms of the interrogatories, I'll just repeat what I told you before. In a civil case, you can propound interrogatories on a party to the case. I don't think there's anything that allows you under the Superior Court rules to propound an interrogatory on a non-party. You are free, obviously, by agreement or by notice, to depose any non-party that has information about this particular claim. But you just can't send an interrogatory, for instance, to Attorney Hilson that's for one of these people you've named and say, have them answer that. His response is going to be, I can't. I don't represent them, and the rules don't allow it. So, I guess, Attorney Hilson, I'll ask you, in terms of your motion for protective order, do you agree with me that I should just hold that in abeyance until we're at the point in the case where we're ready to go forward with discovery, and hopefully, if we've narrowed the issues down, you and Mr. Furlong can agree on what the appropriate nature and breadth of discovery is?
The answer is yes, but all I'm trying to avoid here is really having to come back up to OSPI and argue a motion for conditional default based on those interrogatories that were propounded. I mean, there's problems with them. I think it's going to be, with my interrogatories, I really focused on this one thing. I just want to make sure that we don't have to go through that. In fairness to Mr. Furlong, he answered the interrogatories. I'm not totally happy with the answers, but he answered them, and so I agree with your ruling that conditional default should be stricken. I just don't want to be back here, at least before I have an opportunity to answer an amended complaint.
All
scope of this matter, I don't think that's going to be fruitful. I think we're going to end up, Ed Meyer's going to be fighting over, whether or not it's appropriate, and I'm going to come back here and say, we need some instructions on this line of question. It's going to be a mess, and I think if we have an amended complaint and an answer, those depositions are going to go much more smoothly. That's really my thought process on this.
My view of that is basically that this protective order simply seeks to delay any discovery responsibility until such time as we get the complaint, the amended complaint, get the answer to that. I think that's appropriate. In terms of striking interrogatories that have been made directly to John Ebert, I think that's appropriate too. Any interrogatories have to go directly to Attorney Hilson or the named defendant. So at this point, I'm going to grant that particular motion for protective order in line with the other order that I issued for the amendment.
Can you, excuse me, Your Honor, may I speak?
Yes, you may.
Can you put an exclusion of Gene Chandler interrogatory prior to, well, I guess,
I would prefer not to, just that you can do your interrogatories to Gene Chandler, no doubt about that. You could start working on them, but I think it makes sense not to do them until you've done your amended complaint, he's done his answer, you've got a structuring order with a deadline for interrogatories, and you move forward.
yes, sir.
I'm not in any way affecting your right to do that. You have a full right to do that.
Yes, sir, and I just wanted to get it for the record. I realize that I have to do the amended complaint, and then this way I don't have to file a motion, directing or asking the court to allow me to propound interrogatories on Gene Chandler. If I hadn't mentioned it today, there could be a chance that Mr. Hilson would say, well, so I just wanted to put that for the record, sir. Thank you.
interrogatories out and answer, and then do the appropriate depositions. Obviously, if there are any disputes about that, then parties will have to come back to me or Judge Ignatius, whoever is assigned to the case to resolve those disputes. That takes care of all the motions that were scheduled. I'll also just do a quick notation